Good afternoon. Welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. We, of course, welcome those who join us on all of these occasions on our heritage.org website, those who are viewing us today on C-SPAN. And for those in-house, please be so kind as to check that cell phones have been turned off as we begin. And, of course, our online viewers are always welcome to send questions or comments simply emailing speaker@heritage.org. Hosting our discussion is Hans von Spakovsky. He is our Senior Legal Fellow in the Edwin Meese III Center for Legal and Judicial Studies. He is an authority on civil rights, civil justice, the rule of law, and government reform. He also serves as our manager of Heritage's Election Law Reform Initiative. He is studying campaign finance restrictions, voter fraud, voter ID, enforcement of federal voting rights laws, and the administration of elections. He is the co-author with John Fund of the book, Who's Counting? How Fraudsters and Bureaucrats Put Your Vote at Risk. Before joining Heritage, among his work, he served as 2 years as the member of the Federal Election Commission. He was also worked at the Justice Department as counsel to the Assistant Attorney General for Civil Rights. He has been a litigator, in-house counsel, and senior corporate officer in the insurance industry, and he has also served on the Board of Advisors of the U.S. Election Assistance Commission. Please join me in welcoming my colleague, Hans von Spakovsky. Hans?
Well, good morning, everyone, and welcome to our Heritage audience, and also, as John said, welcome to our C-SPAN viewers. We all four just came from the U.S. Supreme Court, where they actually heard arguments this morning about this case, Williams-Yulee versus the Florida Bar Association. This is the first case that the court has heard oral arguments in a campaign finance issue since last year, when they heard McCutcheon versus FEC, and in that case threw out aggregate limits on campaign contributions in federal campaigns. Now, this case is about state elections, not federal elections, and it's a case about this particular issue. Florida, like 24 other states that have candidates running for judgeships, they have judicial elections, bans personally soliciting political contributions. In this particular case, a judicial candidate in Florida, Lynell Williams-Yulee, sued after she was disciplined by the State Bar Association because she signed a letter that was mass mailed out to voters and was also posted on her campaign website. She claims that this solicitation ban is a violation of her First Amendment rights to engage in political speech, especially since the state does not ban judicial candidates such as her from knowing who gave to their campaign, and doesn't ban them from actually sending thank you notes to the individuals who contributed. The Bar Association argues that this ban is necessary to ensure the impartiality of judges and to prevent the actuality and appearance of corrupt influence on their elections, and that the ban does not violate the First Amendment. I'm going to introduce the three panelists that we have here today, and I have to tell you I'm very honored that they, on very short notice, agreed to come here, and I'm going to introduce all three of them and then let them speak. We're going to start with James Bopp. James Bopp filed an amicus brief in this case on behalf of a number of lawyers who ran for judicial offices in Arizona, Kentucky, Minnesota, Indiana, Wisconsin, and Kansas. From his offices in Terre Haute, Indiana, he has made his mark as one of the premier campaign finance and First Amendment lawyers in the country. He's the general counsel of the James Madison Center for Free Speech, whose mission is to protect the First Amendment right of all citizens for free political expression. He has litigated many important cases before the U.S. Supreme Court and elsewhere. I can't begin to list them all, but they run from Wisconsin Right to Life to his involvement in the McCutcheon case. He is a commissioner of the National Conference of Commissioners of Uniform State Laws and a member of the National Board of Governors, the Republican National Lawyers Association, as well as numerous other organizations. In 2011, NPR called Jim Bopp the country lawyer who has done more than anyone else over the years to upset the status quo in America's political money laws. I don't always agree with NPR, but I think that's a pretty good assessment of Jim Bopp. Second, we're going to have actually Justice Randall Shepard speak. He's the former Chief Justice of the Indiana Supreme Court, and in 2006 led the National Conference of Chief Justices, who actually filed an amicus brief in this case also. When he became the Chief Justice of the Indiana Supreme Court in 1987, he was the youngest Chief Justice in the United States. And when he retired, he was the longest-serving Chief Justice in the nation. He authored more than 900 opinions for the court and has published more than 64 law review articles in 23 different journals. He also has served on the board of many different organizations and commissions as a former trial judge and a federal official. And in 2009, he received the Dwight D. Opperman Award for Judicial Excellence from the American Judicature Society. Finally, we're going to have Robert Corn-Revere speaking. He also filed an amicus brief in this case, but on behalf of the ACLU. He's a partner at Davis Wright Tremaine, and he's one of the leading First Amendment and communications lawyers in the nation. He's been involved in some of the leading cases in this area, including FCC versus Fox, the 2012 Supreme Court case on broadcast indecency. The Supreme Court cited the amicus brief that he filed in 2012 for the Reporters Committee for Freedom of the Press in the Stolen Valor Act case, U.S. versus Alvarez. He's the national chairman of the First Amendment Lawyers Association and an adjunct scholar at one of our friendly competitors, the Cato Institute. He has received countless awards also for his work, including the 2014 Kenneth B. McLaughlin Award of Merit from the National Press Photographers Association. We're going to start with Jim Bopp, and Jim, you can either sit there or come up here, whichever you'd like.
Sit here? All right. Thank you. The consensus is we'll sit. In my view, this case is the latest in the many chapters in the struggle over the proper role of the courts in our society. Our Constitution conceives of the judiciary as having a very limited role. That is, interpreting and implying constitutional provisions and statutes to the facts of an individual case. State court judges have a similar role with respect to state law and application of state constitutional provisions and state statutes to the facts of an individual case. However, state court judges also have a very robust role in developing the law, which federal judges do not have since the decision in the 30s in Erie Railroad. The federal judges got out of the business of developing a federal common law. However, state judges in all but one of the states have a very robust role in the development of that law, subject to legislative enactments. So even with respect to state court judges, they have a limited role. They are not supposed, except in the development of the common law, they are not supposed to impose their own personal policy preferences on on what constitutional rights exist within the state constitutions, or what are the proper statutes that ought to exist to regulate people's conduct. Now, since the Jacksonian era in the 1820s, when popular sovereignty became the watchword, and this was then reinforced by the abolitionists, every state that has formed a state judiciary has provided for popular election of those judicial officers. And that is because the people who wrote those state constitutions believed that if you had the judges accountable to the people, not to, for instance, the governor or the political elites, that we would ensure that the judiciary would be faithful to their limited role of interpreting and applying the statutes and constitutional provisions, and would similarly develop the common law in a way that would favor the people, not the political elites. Well, this idea of popular sovereignty and responsiveness to the people, and ultimately accountability to the judge's limited role, came into conflict in the progressive era with the thinking at that time in the early 1900s. And of course, the progressive era rejected the whole idea of popular sovereignty, and in fact believed quite strongly in the rule of the people by the elites and by specialists who knew better than the people and could create a better society. So as a result of that thinking, the popular election of judges came under attack. Well, this attack was reinforced in the modern era. The modern progressives, the liberals, more commonly known, who believe in the idea of a living constitution. They reject the idea of a fixed understanding of the Constitution and statutes based upon what the meaning of the words were and the intent of the framers, but view the Constitution much more, and often statutes, in a much more flexible way, which allows the judges to pour into the Constitution their own personal policy preferences, and ultimately endorsing a liberal agenda. And we've certainly seen in the federal system and in a few states, but certainly in the federal system, examples, perhaps numerous examples, where the courts have not been faithful to the Constitution and have implemented the liberal agenda. So we have a concerted attack on the idea of a limited role in judges faithful to the Constitution, and that has resulted in two efforts. One effort has been to eliminate election of judicial officers in the states. About as far as they've been able to get is in about a dozen states where they have merit selection, meaning selection of judicial officers through some sort of panel appointed by the elites in the political system, and then a retention election, which is not a real election at all in most instances. Secondly is to nullify campaigns in elections. And this began in 1924 with the first Judicial Code of Ethics, which severely limited the ability of candidates for judicial office to participate in their own elections, and included things like the announce clause, which prohibited judicial candidates from announcing their views on political and legal issues. It also included prohibiting the solicitation of campaign contributions. Well, limiting campaigns for elections, of course, ran right up against the requirements and the protections of the First Amendment, because political speech is at the core of the First Amendment, and of course the First Amendment prohibits any laws that would abridge the freedom of speech. And what they meant in that instance in the First Amendment was campaign speech. And of course, these were severe limitations on judicial candidates' ability to participate in normal campaign activity. Well, this conflict between the First Amendment and these judicial codes of ethics culminated in the 2002 case of Republican Party of Minnesota versus White, which I was privileged to argue before the U.S. Supreme Court as lead counsel for the Republican Party of Minnesota. And there it was the announce clause prohibiting judicial candidates from announcing their views on disputed legal and political issues that was before the court. And in a 5-4 decision, the court struck down that canon. They fully applied the First Amendment to judicial races, even though there was a very vigorous argument on the other side that judicial elections should somehow be exempt from First Amendment protections, or that there were sufficiently compelling interests that would allow such draconian limitations as the announce clause, essentially limiting judicial candidates to talking about their resume. Well, after the White case, numerous canons of restricting campaign activity of judges have been struck down, while in most instances by the federal courts, while in most instances state courts have upheld the restrictions, which now brings us to the case before the court, which was one of the original 1924 limitations on solicitation by judicial candidates of contributions to their own campaign. Ironically, the 11th Circuit, which covers Florida, struck down an identical Georgia canon that prohibited personal solicitation by judges of campaign contributions, while at the same time the Florida Supreme Court upheld the canon. That is certainly one of the reasons why this case is now before the Supreme Court. Numerous circuits had struck down such judicial canons, while many state Supreme Courts had upheld them. Well, this is a substantial restriction. It is known that the candidate for any office, whether it be judicial or otherwise, is the most effective fundraiser for his or her campaign. And such restrictions on personal solicitation by judges of campaign contributions can be expected to substantially reduce the amount of money that can be raised by a particular candidate. Now, significantly, it should be understood that this canon really only restricts the candidate's him or herself from raising money, which handicaps the candidate if independent groups decide to get involved in that election, and of course they can raise funds without limitation and restriction. It means that the candidate, him or herself, has much less money to deal in an environment where you have independent spending, so it actually victimizes judicial candidates ultimately in this competition. So that's the kind of the lay of the land, and now we will hear from the others about the validity of the particular canon at issue.
So, Judge Shepard?
Thank you. Delight to be here today, as it was to be in the court this morning. I have 4 points to make, and some reflections on what justices asked and what answers were given an hour or so ago. I want to begin by posing the question, or making the point that this canon, in fact, doesn't touch very much. What does it leave unfettered? Candidates are unfettered with respect to their ability to speak on issues or qualifications or ideas. Unfettered is what the court in Schaumburg called persuasive speech. Left unmolested is how much money a candidate can raise or spend. None of that is touched by this canon. And likewise untouched is the whole realm of independent expenditures. So as one or two justices asked this morning, they might have said, where's the beef? I mean, most of the things that we identify as political speech aren't covered by this part of Canon 7. Put another way, is this really core speech, yes or no? And I put it to you that the difference between I stand for thus and thus, vote for me, or my qualifications are such and such, you should elect me, the difference between that and give me money is relatively easy to see. And that's what this case is about, as Justice Sotomayor, for example, indicated. It's a request for a financial transaction connected to the larger election, to be sure, but acknowledged, I think, finally by the petitioners to be of a different character. Second, lawyer and judge speech really are different, again, acknowledged this morning by the petitioners. There are plenty of places in society where, First Amendment notwithstanding, we compel people from not to say certain things, or we compel them to say certain things. This is easy to see in the world of finance, for example. You can't put out a securities offering without including certain information, or you won't get registered. There's a penalty for doing that. Lawyers and judges especially consent to these requirements when we decide to become members of the bar in the first instance, so that there are ways in which a lawyer's speech is limited. A lawyer can't stand in front of a court and knowingly speak falsely about the record or about the facts. He may not end up in jail, but he's certainly going to have a problem with his law license, and he ought to. And the same is true with respect to judges. Now, does the First Amendment apply to these situations? Yes. White and Caperton tell us that it does. And what we're really about this morning, the court was about this morning, was finding what parts really matter and how should the court draw that contour for people who are engaged. One of the differences that was discussed this morning was the fact that there are federal laws and federal rules that apply to people like Congress and federal judges, and those are really quite serious. Members of Congress are prohibited from soliciting campaign contributions from federal employees. Well, why is that? The same reasons that were lifted up this morning for this rule about judges directly soliciting lawyers or people who might be in court apply there. And as Justice Kagan said, well, why is it, wouldn't my canon have to fall? Wouldn't the one, she's rare in this field that for a federal judge to lift up. Well, what does this mean for us? Mostly they talk about state judges as if we were from some foreign country. But Justice Kagan this morning said, why would it matter to anybody if I solicit money for my old law school? I think I know which one she had in mind. Why would that really matter? And of course, the petitioner hard-pressed to tell her that it was the same, but she was on a track that really mattered. There are some certain solicitations. If you, for example, solicit a federal employee for a federal official, the law compels you to speak. It compels you to tell the federal employee that he or she has the right to say no. There's kind of compelled affirmative act. So the difference this morning that I think was recognized between not only between lawyers and judges and other office holders is pretty important, including the one that one of the differences between people like governors, senators, members of the House of Representatives, legislators, is that we expect them to be instrumentalities of our wishes. We vote for them because we think they will do certain things that we believe represent good policy. Judges, we hope, are people who will instead read the law, look at the facts, and do the best that human beings can do to give an impartial answer. Now, I think that the case law in this, one could pick out a piece or another piece and decide this case in either direction. Which leads me to the larger point. What is it we'd really like to have in our courts? What do we want to discourage, and what are we willing to encourage? And I put it to you that, that today's argument and several other cases brought along these lines are that we want judges to be more like the political branches. Now, we used to have that in this country. We had judges who were part of the political branches, and it is, according to Thomas Jefferson, one of the causes of the Revolution, to get judges out from under and aside from the people in the executive and legislative branches, many times against whom citizens were litigating in the first instance. And if one decides that you'd like that, striking down this canon is an excellent start. The former Chief Justices from Alabama and Texas have told us what you get when you leave this unfettered. Their briefs record, for example, a judge's email sent after election to a lawyer who had donated to his opponent saying, now that it's all over, I hope you will join in my campaign fund to the same extent of the $2,000 you gave trying to defeat me in the election just passed. Oh, and by the way, there are very few places where late payment doesn't incur an upcharge. Another example in which a Texas judge wrote saying to a variety of law firms, all the big firms have maxed out. And if I'm going to get the kind of money I need your firm to max out as well. And as several judges today said, harder to say no when that request comes directly from the sitting judge, or for that matter, from somebody whom you think might be a judge. Now, are there worries about this rule? One of the great debates in the briefs, not quite as much this morning, was does this rule cover too much or not enough? And as Justice Breyer said, well, not every legislative solution or not every court solution has to solve every single problem. Chief Justice Roberts, for example, said, well, what would be wrong with my calling my old pals from school? And our impulse is to think, how could that be? Where's the corruption in that? Until you parse it out and you say, well, how old is old? How pal is pal? How far off do I have to be before I'm in the zone of safety? Is the question that the solicitor would have to answer at her peril. Likewise, on the question of overbreadth or under-inclusiveness, as Justice Kagan said today, well, so you've demanded that they do more. Florida isn't tough enough. That's why it's unconstitutional. And they're trying to be narrow, to be restrained in what sort of speech is prohibited, and you're criticizing them because they haven't covered every jot and tittle. So the question is, what sort of judiciary do you want to have? And maybe it is, as one of the great questions this morning was, do you create in the judge an impulse to pay off later, to do the quo for the quid? I thought was a very insightful point made by one of the members of the court, and one could do that, right? I mean, Senator Rand Paul gave a speech at Heritage just a week ago in which he said, "What we need is more activist judges in this society. We want more. The country would be better off." This is sort of running contrary to usual form, right? But we want more activist judges. Why is that? He said, the reason is because legislatures do bad things, and activist judges will strike them down under the bad things clause, no doubt, that got left out of my printing of the Constitution. But these things happen. In the last election cycle, a person who was running for the Supreme Court of Ohio spoke right after and on the same platform as Governor Kasich, and saying, if you believe in what Governor Kasich stands for, you've got to put me on the Ohio Supreme Court because I'm his backstop. That's not the America that led Thomas Jefferson to say that bringing judges aside from the rest of the government was a reason for the revolution. But it is a possibility. I mean, you could decide that that's what you wanted, were judges who would do what the elected branches wanted to do. I once asked Bob Bork whether a judge who was elected should feel freer to make policy, not just in common law, but freer to make policy through constitutional law or statutory interpretation in a way consistent with the judge's own policy preferences. And Bob Bork gave, in a sort of classic Bork form, what I thought at the time was a rather flippant answer. He said, "Why would the taxpayers pay for that twice?" And by the time I got home, I decided that was a pretty good answer. It had struck me as a little odd at the time, but it was, if anything, a fiscal conservative answer. Finally, on fourth and finally on overbreadth, not broad enough, narrows and tailoring and so on, I want to say that the only person who filed a brief in this case who actually said, "I think the following would be constitutional," was Jim Bob. Most of the other amicus lift these up as sort of tantalizing possibilities. Well, what if a mass letter only went to 50 people? What if is what they usually say. What Jim Bob says is solicitation in the courthouse can be prohibited consistent with the First Amendment. And now that draws the line a little farther over than I would draw it, but he had the courage and sense, it seems to me, as an advocate, to say there are some things here that can be prohibited. And most of the people arguing this case don't do that. They sort of put that over somewhere else. Here are the things we'd be willing to say. And frankly, and most of the arguments seem to me, most of the briefs, most of the amicus briefs, I don't really think they would stand for approving most of the alternatives that they lift up as possibilities. The same is true with respect to recusal. There was almost no discussion of recusal this morning, but it's very common in the briefs as a way of saying, well, that's a more narrowly tailored solution if you get a judge who's not impartial because he or she has received or solicited, I guess, contributions. There are two problems with that. Is one that's a little hard to know when and where the solicitation occurred, or is this a solicited campaign contribution or one simply sent out of the good graces of the donor? It by definition happens beyond the view of the rest of the public. But the real problem with it is that if the campaign contribution is designed to promote the sort of speech and the sort of judicial decision that the donor wishes, then recusal makes the election a fraud. It also places in the hands of litigators a handy tool to get rid of judges in front of whom they think their case might not go as well. That is to say, you might want to be sure you've contributed to Shepard so that at the right moment you'd get an exit card. Or you might want to make sure that to take a look at who your opponent contributed to so that you could use that against him or her. Very difficult to figure out. In any event, thank you for the invitation. I look forward to the conversation.
Bob, you're going to finish it up. You were one of those people that filed an amicus brief too. So.
Yeah, one of those deficient amicus
Right.
briefs. First of all, I want to thank the Foundation for inviting me to be on this panel. I'm humbled to be in the presence of these other speakers. Hans, thank you for your kind introduction. I should begin by saying that I did file an amicus brief for the ACLU in this case. I'm not here today appearing as a spokesperson for the ACLU, but just as someone who's participated in the case in that way. And so the views today and all the mistakes are entirely my own. First of all, a little bit of background and context. This case comes 13 years after the Supreme Court decided the terrific decision in Republican Party of Minnesota versus White, Jim Bob's terrific victory in 2002. It struck down a judicial conduct canon that prohibited candidates for judicial office from announcing their views on disputed legal or political issues. We are 5 years, almost to the day, after the decision was handed down in Citizens United. So there's a lot of context in which this case comes to the court. Also, I should say, it's not, as any of the cases that the Supreme Court grapples with, it is not an easy case. The circuits, as Jim mentioned, are split on this. The 6th, 8th, 9th, and 11th circuits have struck down canons like this. The 3rd and the 7th Circuit have upheld them, and all of the state Supreme Courts that have looked at canons like this have upheld them. So it's no surprise that this is going to be a case that the Supreme Court is going to have to wrestle with, and the arguments that we witnessed this morning, I think, are pretty good evidence of that. Now, I have to say that for the Roberts Court, when the current Chief Justice ascended to the court, in his confirmation hearings talked about trying to seek greater unanimity on the court. There's been a lot written about that, and I think you can see some movement in that direction in recent years. As recently as the October 2008 term, only 33% of the court's decisions were unanimous. That number has gone up fairly consistently over the years. Between 2009 and 2012, it was in the mid-40s, and last term, 2/3 of the court's decisions were unanimous decisions. So you can make of that what you will, but it means that there is an effort by the court to try and make sense of the law in a way that can achieve some kind of consensus. That's not going to be the case today, I'm afraid. Just listening to the arguments today and looking at the kinds of issues, and also looking at this area of law. The political campaign cases that have come to the court in recent years have not been unanimous decisions. 80% of them have been decided by 5-4 decisions. And so it is an area that does divide the justices. And I think that, again, was evident in the questioning today. In this case, there were 17 amicus briefs filed, 4 supporting the petitioner, 13 supporting the state of Florida. And so there's a lot for the court to consider. Now, the issue itself is an interesting one. I don't think it's as simple as sometimes the state gets to prohibit some kind of speech, sometimes it gets to mandate some kind of speech, so why not here? Because it's just a little bit of speech. We're talking here about political speech, a direct restriction on what candidates can say. And it's the kind of speech that historically the Supreme Court has said the First Amendment places the strictest limits on the government's ability to restrict what candidates can say. And the issue that the court isolated and made clear as a prevailing principle in the White case that Jim argued was that if the state decides to have judicial elections, then it has a very limited ability to limit what candidates can say. It doesn't have to choose elections. The federal system is not based on elections. States have chosen, most of them have, to elect their judges. And with that comes the constitutional right to be a candidate. And having made that decision, then it creates these really complicated questions about where you draw the line, what kinds of restrictions on judicial ethics are permissible, and which ones are not. In this case, the question is whether or not the restrictions adopted by the state of Florida make any difference at all. Justice Shepard says that we're not talking about limiting what candidates can say on the issues themselves. They can say all of that. They just can't ask for money, which is, by the way, one of the main things candidates do. But nonetheless, there's a lot that Florida doesn't restrict. For example, Canon 7C1, while it prevents candidates from making direct appeals, like in this case it was a mass fundraising letter, it doesn't prevent the candidate from establishing committees of responsible persons to secure and manage the expenditure of funds for the candidate's campaign and to obtain public statements of support for his or her candidacy. Such committees are not prohibited from soliciting campaign contributions and public support from any person or corporation authorized by law. So you can send the exact same letter out. It's just that if you sign it, as the candidate did in this case, she can be subject to sanctions. She can be made, in this case, she was given only a letter of reprimand and required to pay costs of around $1,800. But nonetheless, the campaign can still send out that message. Now you might ask, what's the problem then? The campaign can still be funded. The only problem is the candidate can't speak. And the problem there is the First Amendment. If you're going to pay a First Amendment price, if you're going to restrict what people can say, then you have to show that the government is actually serving the interest that it's designed this restriction to serve. And in this case, the problem is where a candidate is prohibited by Florida Canon 7C1 from saying, please. Nothing prevents the candidate, after the committee asks for a contribution, from saying thank you. The judicial candidate can know who gave to the campaign. They can, I suppose, hold a barbecue for everyone who contributed to the campaign afterwards. All of the same dynamics that are described as corruption still happen. You simply don't have that candidate signing that initial letter. And so you're penalizing people for speech for no purpose. And that was the line that the justices, I think, were trying to get at today. How can you adopt a regulation that actually serves some kind of purpose without adopting a regulation that goes too far in restricting speech? And I think there were a lot of questions that got to that, many questions involving what about the thank you note, but none of them that really honed in on where that exact line is. And I think that's where that close division among the justices in this area is going to play a significant role. Again, it kind of depends on how important you think First Amendment is in regulating campaigns. I've always been a little confused about this area myself. When I think about other areas of First Amendment law, usually if the regulation doesn't serve an interest, then it's invalid, even under less rigorous judicial scrutiny. So, for example, in the area of advertising, if the restriction on advertising doesn't actually prevent the problem, then that restriction is invalid. The same is true in pretty much every other area. But it seems like the operating principle underlying most of people who advocate various kinds of campaign finance restrictions is that political speech is just far too important to be free. And I've just never understood that principle. I guess the only other thing that I would say is that there was a question that Justice Ginsburg asked early in the argument that I think did get at why this is going to be such a difficult case to answer, that it is different from other areas of political campaign restrictions, and that is because it does deal with the judiciary. You know, she asked Andy Pincus, who was arguing for the petitioner early on, would the First Amendment permit us to prohibit a congressional candidate, for example, from asking a donor to contribute to the campaign? And doesn't this mean then that there are certain restrictions you can put on judicial candidates that you can't put on others? I should back up and say that as a preface to that, Mr. Pincus had made the concession that the First Amendment would permit a restriction that prohibited a judge from going up to a litigant or in the courthouse making a direct appeal. And I agree with that assessment. The First Amendment would permit that kind of direct appeal. And in being given that answer, then Justice Ginsburg asked, well, doesn't this mean that we treat these candidates differently from other candidates? And once you accept that premise, then you've got to answer, how differently can you treat them? How far can the state go in restricting these kinds of appeals? And can we adopt these restrictions basically for their symbolic value, that we want judges to be different? Which I'll end on the question Justice Shepard asked, and that is, what kind of judiciary do you want to have? My own personal answer to that question is, I want an unelected judiciary, and you don't have these problems. Different people may answer that question differently, but I think the root problem isn't that we have to figure out which of these fine-tuning measures is going to be the right one. I think the answer is we take politics out of it entirely, or at least electoral politics out of it, and you don't have candidates that are judges.
Thank you.
All right, I'm going to come up here and we'll take questions from the audience since we have plenty of time. But I want to hone in on something that you all talked about a bit, and that is that you could really see in the questioning this morning, and it was particularly the questioning by Justice Breyer and Justice Scalia, honing in on the fact that it was very clear that Justice Breyer thought there was something really different, more coercive, if the judge is actually doing the solicitation. Whereas it was very clear that Justice Scalia and some of the other justices thought that, well, if the whole idea of is to avoid quid pro quo corruption, how are you going to do that when the candidate not only can write thank you notes to those who have given them letters, but can actually give a list to his or her committee of who they should contact to do that? Is that you think that's a really crucial issue in how the justices are going to decide this case?
I think it points out how difficult it is to really claim their significance here as far as the distinction that the Florida is trying to draw. Because Florida would allow a letter that says the following: I'm a personal friend of the judge who has asked me to serve as his chairman of his campaign committee. He has given me your name to ask that you contribute, and I'll of course be reporting to him. And if you contribute, you'll be, not only will the judge know, but you can expect to receive a thank you note from him for giving the contribution. Now, how is that? Is there a constitutionally significant difference between that letter and the judge writing a letter and saying, you know, this is Judge Joe Blow, I'm running for a judge, I'd appreciate a contribution for my campaign? Because the message is the same, that is the solicitation. And is it really so different that it is from a candidate's campaign chairman in the way I described and the other? So this is, reminds me of, angels dancing on the head of a pin. I mean, and of course, the context is the First Amendment applies to this activity. Justice Shepard kind of poo-pooed it, that candidates soliciting contributions, but there's two things about that. Number one is by far the most effective solicitor of a candidate's campaign is the person, him or herself, and that's regardless of what the person is running for. It doesn't matter whether it's for judge or for Senate or for governor. I mean, come on, think about coercion. How about if a gubernatorial candidate looks you in the eye and says, yeah, I'd like would you mind contributing to my campaign? If we view, a judge that you may not ever appear before and a gubernatorial candidate, and you have a business in the state, who is more persuasive? If that's really what we're talking about, again, it's really hard to draw these distinctions, and that's why the First Amendment context matters. This is core political speech. Number one is exactly what the First Amendment had in mind, and the founders and the writers of it when they wrote the First Amendment was campaign activity, and campaign activity includes solicitation. And it's by far the most effective means to raising money for your campaign. And what is that money for? Doing speech about your campaign. So, and I think the reason that it was prohibited goes back to the fact that though the people, by and large, and not exclusively, but by and large, who support these restrictions do so because they want to shut down elections. And so they know this is important, that to have a candidate actually make the solicitation. And by prohibiting it, it is a big hit to that campaign and to the campaign of all judges for judicial office. It goes toward ultimately driving campaigns out of judicial elections and thereby nullifying what the people want, which is the kind of judges that are restricted to their roles, and it seems to be necessary to have judicial elections to make the judges accountable to the people, to make sure they are restricted in their roles.
Anyone else? Bob?
Well, I was just going to say, it's interesting that for two people who filed a brief seeking the same outcome in this case, and that is the Florida canon being struck down, there's so much we disagree on. But I think the point that you isolate was the same thing that troubled the justices this morning, and that is that the candidate himself is the most effective person for appealing for funds. And this is the thing that bothered Justice Breyer in particular. It also bothered Justice Ginsburg, and that is saying that there is an inherent coercive power when a judge asks for money. This was the point that he made through a number of questions, and that this is the kind of thing that the state is trying to prohibit here. And if, in fact, the candidate is the most effective person in asking for money, that would be one reason for that. Now, there can be many reasons why that might be true, but to me, that suggests that there is an interest here in preventing judges from using their roles to gain in the electoral setting. On the other hand, when you look at what is allowed, when you look at the fact that the best friend, who happens to be the campaign manager, can write the same letter and send it, and send a list, and then the judge can write thank you notes and be aware of who contributed, and more importantly, who didn't contribute, then the Florida canon does nothing to serve the purported interest that Florida is trying to solve, and all it does is restrict candidate speech. So I would agree with you that when it comes to whether or not the regulation is over-inclusive or under-inclusive, it's got some severe problems. I don't think it can survive constitutional scrutiny, but I don't think that you need do nothing simply because the judges themselves are the most persuasive money getters. I mean, I think that's the problem that Florida is at least trying to solve.
I suggest that if Florida had a rule that put the hammer down on all the places where you say it doesn't now, your client would be in the same posture that your client was in today, which is arguing that none of those should be tolerated under the First Amendment. I thought one of the interesting things about today's argument was Justice Scalia's repeated references to dignity. And back in old-fashioned America, we used to think dignity was worth something. You know, that it mattered, that the people that we placed in office or in other positions of trust could be seen in that way. In most of this litigation, dignity has been, not just this case, but in the field in general, dignity has been brushed aside as having no consequence of any value. And indeed, in most of these briefs, or not, I wouldn't say most, there are a number of amicus briefs in which the claim is made that public confidence is not a particularly compelling state interest either, which is sort of second cousin to that idea. It seems to me that what Justice Scalia might do is connect the notion of dignity to the entitlement to due process. That's what's at stake. It isn't sort of whether thank you notes are good, bad, or indifferent. It is whether you create circumstances under which individual litigants can walk into the courthouse and not worry in ways they shouldn't have to worry about whether the judge who's going to decide the custody of their granddaughter is somebody who's going to be influenced by the fact that the last time he went to the lawyer on the other side and asked for $1,000, he got it. The people who walk into court knowing that don't feel very good about justice in America, and that's one of the things this canon is designed to keep from happening.
And I would like to ask Justice Shepard two questions. One is, what is undignified about soliciting campaign contributions? In other words, are all our senators and all our congressmen and our governors and our presidents all a bunch of undignified people because they have to, because they solicit, campaign contributions? I don't think there's anything inherently sordid or, or nasty about soliciting a contribution. And of course, particularly when we're talking about, in this case, just signing a mass letter. So what do you think about that?
Well, actually, I do think that it's hard to argue that dignity has constitutional value, but that's why I don't usually use it. And it struck me as unusual that it seemed to be an issue for him because it doesn't get any traction in this setting. I will say that if you were to ask most Americans, would the nation be better off if all the judicial elections looked like congressional elections, all the big money spending by special interests and the running of attack ads, wouldn't we be better off if America had that in its judiciary too? That Americans would probably say no. I think I'd rather take a different approach.
Well, yeah,
and I agree with that. I think they don't like campaigns generally, and so if you say we're going to have more campaigns, they say, oh, how horrible, because they don't like campaigns generally. But if you ask them, as the ABA did in 2000, if you ask them this question, which judges are more fair and more impartial, which I think are the judges we want, fair and impartial, which are more fair and more impartial, judges that are elected or judges that are appointed? What they said, 3/4 of them said, elected. In other words, the kind of judges we're most likely to get are people that are elected. And I think that's because the American people feel innately, inherently, that if our public officials are responsive to the people, not to the elites and the big shots and the people down inside the Beltway, or our equivalent of the Beltway, then we're going to have more fair and more impartial judges.
Go ahead. Then we'll take a question from the audience.
Yeah, well, my brief answer to the question of judicial dignity, which was interesting because Justice Scalia kept coming back to it, and I thought it was a very interesting point. But if you're really concerned about judicial dignity, don't make them candidates. Why in the world would anyone think that that's a good solution? To take up the hypothetical that you raised, do you really want a judge who knows that the lawyer on one side contributed to his campaign? Well, you have that anyway. The judicial canon does nothing. You've made them candidates. They're going out and raising money. The only thing that the judicial canon in Florida changes is that they don't sign the letter at the bottom asking for that contribution. They still solicit the contribution through their committee. They still get the contribution. They still know who gave the contribution, and they still say thank you at the end. So the problem isn't the fact that you can actually make a direct solicitation appeal by signing a mass fundraising letter. The problem is that you're allowing these people to be candidates. Now, the question of having an elected judiciary versus an unelected judiciary, I always thought that that was one of our primary checks and balances. The last thing I want is a judge, when I go in to argue a constitutional case, that is going to base his opinion on the latest polls or whether or not he thinks it's going to affect his chances of being reelected. I would prefer to have a judge that is vetted for his qualifications and is committed to the principles of adhering to the Constitution as he or she interprets it. And I think elections, excuse me, get in the way of that.
Well, that's going to have to be another debate that we have, perhaps another session on elected versus appointed judges. Although I have to tell a very quick story, which is I used to be an in-house corporate counsel, so I handled litigation all over the country. And inevitably in the states where the state judges were appointed, the local lawyers would complain to me about how terrible the judges were because they were all people who were, friends of legislators and the governor and stuff. And then I would handle cases in states where judges were elected, and inevitably the local attorneys would complain about the judges saying, "Oh, these terrible people that gotten elected." So there were clearly problems with both. Okay, now we're having to take a question from the audience. Anyone? John? And if you would please make it a question and just identify yourself before you ask the question. Thanks.
Sure. John Malcolm here at the Heritage Foundation. My question is that I always assume that any kind of an election restriction, whether it's fundraising or ability to speak, is designed to benefit the incumbent. And so I am curious whether there were any questions today asked from the perspective of what happens if somebody is challenging a sitting judge.
That question did come up.
Yeah, it did. Justice Ginsburg asked it, not just that, but how does it play out as far as networks and inequality of income and so on. And I've forgotten who.
Justice Roberts, too.
Yeah, the best answer was, if you really want to favor incumbents, set them loose to do face-to-face or direct contribution requests. There's the place where nobody can say no, and that the restraint on direct requests is a rule that helps the non-incumbent, even if you thought leveling the playing field was a First Amendment right or something, but you'd have to get there somehow. But yes, who does it favor? It seemed to me not much evidence, no evidence by either side actually in the record. Jim Bopp and I agree completely on who's the best fundraiser. It's the candidate. It's why people from the Hill have separate offices to go down certain hours of each week and start making the phone calls that have been teed up for them, because they have a success rate that's a lot higher than even the best friend who tells you, "I'm going to tell the candidate that you gave."
And of course what he says, everything he just says is right except this, which I think makes the critical difference. If there is no campaign at all, who wins the election? The incumbent or the challenger? The incumbent. With no campaign, somebody who's already in office has a huge benefit of being in office. They get free news media, they get an office and a staff and a travel budget and all this. And they've already demonstrated that they have enough popular support to get elected the first time. So they've already been through a campaign, they have a list of donors, they have a campaign team. In other words, all the advantages go with the incumbent. The only way a challenger can meet that is raise sufficient money to compete. So that's why the incumbent, no campaign, we win. That's why money matters much more to the challenger than it does to the incumbent. So to the extent that you make it more difficult for the challenger to raise money, like you can't solicit, it does disproportionately affect one of the candidates, and that's the challenger, because their job, much more than the incumbent, is to raise sufficient funds to overcome the incumbent's advantages that they have anyway.
Yeah, I would agree with that. And you know, it's true that if you turn everybody loose, the incumbent's still going to have an advantage. But then the incumbent has an advantage anyway. And so the only possibility of leveling the playing field, although I don't think that's a legitimate state interest in the campaign reform context, but the only way that the challenger has any hope is if they aren't restricted in their ability to solicit campaign contributions.
There's a saying among judges that every case produces one angry and disappointed litigant and one ingrate. I would say the reason that incumbents mostly win is because mostly we don't have judicial elections, even where we have judicial elections. That there isn't formal gerrymandering the way there is in races for Congress or for state legislatures. But the fact of electing people by district mostly means that that if whoever won is whoever that party's nominee was, and that the number of actual contested elections is pretty small.
Yeah.
Thanks. I'm Ken Doyle. I'm a reporter from BNA. Just wanted to ask if the panelists agree that the decision in the case is likely to be another 5-4 decision, as most of them are in this area, and with Justice Kennedy as the likely swing vote. And if that's the case, is there any way to tell where Justice Kennedy will come down from the argument this morning?
Yeah, we should mention that at one point I think Justice Scalia said we only need 5 votes.
Yes. Well, Jim Bob and I had a conversation about that on the way over. Early in the argument, Justice Kennedy was testing the petitioner on hypotheticals that had to do with how mass is mass and how direct is direct, and is one-on-one, that's okay. How about 2-on-1? If there are 3 people in the room, does that count? And he ended up by saying, well, then we're off to the races, aren't we? By which he meant we're going to get quite a pattern of fine gradations. I took heart from that, and so did Jim Bob. So I don't know. I don't know what to tell from it. It seemed to me that I took it to mean that he recognized the great difficulty of having judicial opinions kind of work out. How about maybe not inside the courthouse on the steps? How far away from the courthouse does it have to be? Those would be the things that you'd end up with if you say, well, context is all, where this Florida hasn't gone too far, it's gone not far enough, we'll go work it out, is what I got from that very opening question.
Yeah, you can't help but look at these things through your own experiences, and Justice Kennedy has been in the judicial speech cases, particularly in White in 2002, he was the most absolutist in that case in terms of the ability of judges to talk about issues. And in fact, it was interesting because I actually supported a limit on judicial candidate speech, that while they could talk about issues, their general judicial philosophy, whether or not particular cases were rightly or wrongly decided, what they could not do, I thought, consistent with the First Amendment, is announce their views on, is pledge or promise certain results in a particular case. In other words, they could say Roe v. Wade was wrongly decided, case coming up here, an anniversary very soon, was wrongly decided or rightly decided in their view. But what they could not say is, and if when I take judicial office, if Roe v. Wade comes before me, I'm going to strike it down. In other words, that's promising how you're going to exercise your judicial power in the future. And I thought that is that kind of promise, even though a legislator could make it, or an executive officer, somebody running for executive office, could make that promise, is that is inconsistent with the role of the judge. He's got two roles. The other role, which is to decide cases based upon the law and the facts at the time the decision is to be made, not promising how we're going to do it in the future. Justice Kennedy took me to task in oral argument over even suggesting that there could be that limit on judicial candidate speech, and he then wrote a concurrence to explain basically that would be unconstitutional. That limit itself would be unconstitutional. Now, in this case, I do think that, consistent with the application of other laws to campaign activity, that there could be limits on judicial candidates. We said in our brief, and you outed me on this, Justice Shepard.
You stand alone on this. I
well,
congratulate you for doing it. You were more persuasive because of it.
Well, I do believe it, and federal candidates are prohibited from soliciting campaign contributions on federal property. You remember Al Gore was caught raising campaign cash in his vice president's office, and he was taken to task for that because that violated federal law. I think similarly, and I think that's a very sensible time, place, and manner restriction. And similarly, I think a judge could be prohibited from soliciting contributions at the courthouse for the very same analytical reasons. Is a time, place, and manner restrictions, and really we shouldn't be using our taxpayer money to fund an office for a candidate raising campaign cash. I think also they could be prohibited from soliciting people that have cases in their court. Just like, even though a judicial candidate, and including a judge, can talk about cases and how they would view prior cases having been decided, he could be prohibited from talking about cases that are before him or her, and that's a separate canon. So similarly, you can raise contributions from people, but and solicit them, but you should not be soliciting people that are actually, in your courtroom or having cases in your court. And I think those are narrowly tailored. They make sense because they are similar limitations in other areas regarding campaign activity, and they really eliminate the real ones where there is a potential abuse. And even though the canon here, applies to everybody. In other words, a candidate for judicial office cannot call up their mother and ask them for a contribution, or they will be disciplined. That's so people they don't know, people that live in other counties and would never have a case before them, even other states or foreign countries. I mean, they can't ask people that would never appear before them. It's so ridiculously broad for really no logical reason. These boil it down to those where we could say, well, there might be some abuse here, and I think those could be limits.
Well, unfortunately, we don't have time for more questions, but if everyone would thank our panel, we really appreciate you all being here today. Thanks for coming to Heritage.